Post-Arrival Orientation Seminar by Filipino Overseas Labor Office, Tokyo, Japan.
PAOS is a continuation to the Pre-Departure Orientation Seminar, or PDOS, and are part of the Philippine government's effort to equip our Filipino workers appropriate information as guide on their journey to overseas employment.
Today's PAOS will briefly cover the following discussions: profile of Filipinos in Japan, pertinent Japanese labor and immigration laws for foreign workers, services of the Philippine Overseas Labor Office or POLO, on-site programs and services of the Overseas Workers Welfare Administration or OWA, and practical tips on working and living in Japan.
As of June 2016, there are a total of 257,172 Filipinos living in Japan. This consisted of 32,419 registered Filipinos with working visa. 219,513 are registered either with long-term, permanent, intra-company, and training visas. 5,240 Filipinos are undocumented and with overstay status. Filipinos with working visas are classified on the following categories. Skilled workers include positions such as engineers, teachers, interpreters, managers, researchers, cooks, jewelry craftsmen, and horsemen. Generally, they are granted international humanities visas. Specific visas for selected job categories such as engineers and university professors are also granted. Household workers include those who provide household services to employers such as diplomats, foreign investors, executive foreigners. They are granted the designated activity visas. Entertainers consists of performing artists that acquire entertainer visas. There are special setups on deployment of Filipino workers in Japan under these schemes. Nurses and caregivers under the Japan and Philippine Economic Partnership Agreement, or JPEPA. They are granted designated activity visas. Technical intern trainees under the Technical Intern Training Program. They are granted technical intern trainee visas. Construction and shipbuilding worker under MLIT. These group of workers are granted designated activity visas. And household workers under the National Strategic Special Zones Project, who are also granted the designated activity visas.
The employment contract that binds the employer and the worker must have provisions on number of working hours per week, net monthly take-home pay, and availability of affordable accommodation. Provisions on other privileges on any subsidy shall also be specified in the contract. Other important provisions in your contract are the following: termination of the contract by both parties, repatriation of the worker due to death, settlement of disputes, duration of employment, specified workplace, work hours, day off, paid leave, gross monthly salary, statutory deductions, and overtime work. As a general rule, Japanese laws pertaining to labor apply to all employees in Japan, regardless of nationality. It means that the Labor Standards Law, the Minimum Wages Law, the Industrial Safety and Health Law, the Workers' Accident Compensations Insurance Law, the Employment Security Law, and others also apply to all foreign workers.
The following are the important basic provisions for you to be aware of: overtime and statutory deductions, income and residence taxes, social insurance, labor insurance, and annual paid leave. Salaries and wages in Japan are being mandated by the minimum wage law, which applies to all workers. It is computed on a per-hour rate. Practically, the salary that should be received by the worker should not be lower than the prescribed minimum wage. In the case of foreign workers, others are receiving above the minimum wage amount. Any increase in the minimum hourly rate salary prescribed by the host country shall automatically be applied. Prescribed minimum weekly working hours is 40 hours, computed at 8 working hours per day. Rendering work in excess of the prescribed minimum weekly hours is considered an overtime work. Overtime work rendered during regular workdays, including late night work, which is defined as work between 10 p.m. to 5 a.m., is computed at 25% of the worker's minimum hourly rate. Work rendered during statutory holidays is computed at 35%. Overtime work in excess of 60 hours in a month is computed at 50%. It is important that the employer discusses with his employees identification of statutory and non-statutory holidays, as these are important in the computation of overtime pay. The Regional Labor Standard Inspection Office and labor bureaus under the Ministry of Health, Labor, and Welfare handle work-related inquiries such as concerns on salaries and wages, overtime, and work accident. They have installed telephone consultation service for foreign workers. They are entertaining queries on the following schedules. Monday to Friday, assisted by an English-speaking staff, is 0570-001701. Tuesday and Wednesday, assisted by a Tagalog-speaking staff, is 0570-001705. Their operating times are between 10 a.m. to 3 p.m., with a break between 12 p.m. to 1 p.m. The Labor Standards Law stipulates the annual paid leave system so that employees may take leave at any time and enjoy a pleasant life. An employer shall grant annual paid leave of 10 working days, either consecutive or divided up into portions, to an employee who has been employed continuously for 6 months, calculated from the day of hiring, and who has reported for work on at least 80% of the total working days. An employee shall request utilization of paid leave from his or her employer. However, the employee may be asked to change the requested dates if absence in the said period would interfere with the company's normal operations. An employer cannot impose compulsory or forced savings to an employee unless a labor management agreement is concluded by both parties and submitted to the Labor Standards Inspection Office. Income tax is a certain percentage of deduction prescribed by law. The computed amount of your income tax will depend on how much you earn within a year, including your income from overtime work, and is deducted from your monthly salary. Declaration of your legal dependents is material to identify possible exemption from income tax. Proof of your regular remittances for living expenses of legal dependents such as spouse, children, or parents are important documents required for submission when filing your income tax. Dependents' age, degree of kinship, and sharing within same living budgets are some of the considerations for tax exemption. In general, employers assist in filing your annual income tax. But if this is not available, the worker is responsible to file such in the respective tax office. Your annual income is also the basis for computation of your residence tax. You may wonder why there is no deduction for residence tax during your first year of stay in Japan. This deduction will be reflected on your second year. For example, if you arrive in Japan in 2017, deduction for the residence tax will be reflected in 2018. You are advised not to compare your income and residence tax deductions with your colleagues, as this may individually vary depending on the previous considerations cited. Protective mandatory insurances such as social insurance, which will cover workers for health and pension, are part of the statutory deductions. The premium for these insurances are co-shared by both employer and employee. As a regular rule, please be guided that if a worker avails of his or her health insurance, either through medical checkup or hospital confinement, he or she will pay for the 30% of the total amount of expenses. Labor insurance such as employment and work accident-related insurances are also mandatory insurances. Employment insurance premium shall be shouldered by the worker, while the work accident insurance premium shall be shouldered by the employer. The premiums for mandatory insurances are being deducted from the worker's monthly salary.
Under the immigration law of Japan, foreign workers are only allowed to work within a permitted scope of the visa given by the Immigration Bureau. They shall not perform any work activity, additional or part-time, which is not within the specified scope of their respective visa. For example, those holding designated activity visas shall only work in the designated workplace under the designated employer. These information are specified in a slip being attached to the household worker's passport. Under the NSSC scheme, household workers are only allowed to work within the individually approved designated strategic zone, Workers may face charges or deportation if any of these provisions are violated.